It was October 1995 and my phone rang. It was O.J. Simpson calling me for asset protection. 3 days after the verdict came back, not guilty on all counts. I got a call in my office. On the other end was O.J. Simpson and his lawyer asking about a Cook Islands trust. Now here's the part people don't expect when I tell the story. I'm the one that reached out to them first. I lived about 30 minutes north of his house on North Rockingham Drive in Brentwood, California. I'd driven past it more times than I can really count, mostly because every out-of-town guest at that time wanted to go see it. I was already deep into asset protection work at the time, and I did something that was part curiosity, part experiment. I sent him a letter, mostly just to see if it would ever get opened, let alone answered. And I honestly expected nothing. A few days later, the phone rang, and it was his team wanting to sit down and understand how a Cook Islands trust actually works, the structure, the timeline of what it would take. We had a short conversation. I walked him through the structure and what it was. No engagement, no filing, no trust. That's usually where people expect the story to end. But the real story is what that phone call tells you about this entire industry and how it works. And more importantly, what it means for someone like you who's never been accused of anything in your life. Because here's where this strange little story becomes relevant to someone with $2 million, $5 million, $20 million sitting in a business, a portfolio, or a piece of real estate. If you've ever assumed offshore asset protection is something for people running from a courtroom, this video is going to change how you think about it. And it might change how urgently you think about your own situation. Stat: the U.S. sees well over 15 million lawsuits filed every single year, and business owners, physicians, and real estate investors sit at the top of the target list simply because they're visible and they're perceived as having something worth taking. Most of them never think about protecting what they've built until the first letter from a plaintiff's attorney shows up. By then, the calmest and most effective options are already off the table. Now, here's the assumption most people carry into a story like this. They hear offshore trust next to a famous name from a notorious trial, and their minds fill in the rest. A jurisdiction that will take anyone's money, no questions asked, as long as the wire clears. And that's an understandable assumption. It's also completely backwards. Imagine for a second what would happen to a jurisdiction's reputation if every single high-profile defendant in the country could simply show up with a wire transfer and get accepted no matter what they've been accused of. Now, based on 35 years working with trustees directly, 30 of those years spent specifically structuring Cook Islands trusts, more of them, they tell us, than any firm in the world, I can tell you with real confidence that a case carrying that level of notoriety was never going to be accepted, regardless of what the verdict said. This was never about relitigating guilt or innocence. It was about reputational risk. The single most famous murder defendant in modern American history, known around the world, becoming the face of a Cook Islands asset protection trust, would have been a catastrophe for a jurisdiction that survives entirely on its reputation for integrity. And that reputation isn't an accident. It isn't just marketing language. Trustees in a serious offshore jurisdiction like the Cook Islands are evaluating more than just your net worth. They're looking at whether you're currently under government scrutiny, of whether there's active or recent criminal exposure tied to the funds themselves, and whether taking you on as a client creates a level of public attention that the jurisdiction has no interest in inviting. So none of this is published in formal law. It doesn't need to be. It's simply the professional judgment every serious trustee company and jurisdiction applies before they'll take you on. And it means the clients who actually get approved look almost nothing like what people picture. They look boring on paper. That's not an insult. It's the entire point. Picture a 58-year-old surgeon who spent 3 decades building a practice worth $6 million and is just one bad outcome away from a malpractice claim that could take a third of it. Picture a real estate developer sitting on $9 million of equity across a handful of properties who's watched a colleague get hit with a judgment that wiped out 15 years of work. Picture an entrepreneur who's built a company from nothing and only recently realized that owning valuable things personally makes you a personally collectible target. None of these people have ever been on the news. None of them will ever get a phone call from a curious attorney who read about them in a paper. All of them have exactly the kind of exposure this structure was built for. Real world story, and this is a composite built for patterns I've seen repeatedly over the years, not one specific client. Two business owners, both with roughly $4 million in equity in their companies, both in similar industries with similar risk profiles. One of them set up a Cook Islands Trust 2 years before a former partner sued him over a contract dispute. When the lawsuit was filed, the attorney on the other side did the math. They realized the assets were sitting behind a jurisdiction that doesn't enforce U.S. judgments, and the case settled quietly for a fraction of what was originally demanded. The other business owner waited. He figured he'd deal with protection someday, once things settled down or business slowed down enough to focus on it. Someday arrived in the form of a process server at his office. And by then, his options had narrowed to expensive, limited domestic tools that a determined plaintiff's attorney could still chip away at. Same net worth, same exposure, completely different outcomes. And the only variable that changed between them was timing. Now, real quick, if you're finding this useful, please click the like button so they promote this video and more people can see it. And subscribe. Please check right now to see if you're subscribed. All you have to do is, it's pretty easy. It's free. Just click subscribe if you haven't already so you can catch the next one. And if you want to know whether your own situation will actually qualify, and not a guess, an actual conversation about exposure, you can visit us at assetprotectionplanners.com, and there's a lot more free information there. If you're serious and not just curious, you have $500,000 to $1 million or more in assets, you can reach out and speak to one of our consultants. So what does qualifying actually get you? This is the part that sounds complicated, but the logic underneath it is simple once you see it. A Cook Islands Trust isn't a black box where your money disappears and you lose control. In calm conditions, you remain the manager of the operating LLC that sits inside of the trust. You keep full control, and if you've seen it in my other videos, this is something I repeat a lot. Full access, day-to-day authority over your own assets, exactly as you do now. You can still run your business. You can sign checks, make investment decisions, all of it. The separation only activates when a real legal threat appears, a lawsuit, a judgment, a creditor coming after what's yours. At that point, and only at that point, a licensed, bonded, trustee company law firm can step in in the manager role of that LLC for you. That way, a judge can't tell them what to do. They can tell you what to do. That handoff isn't something you can voluntarily reverse under pressure, and that's precisely what makes it legally meaningful. When the problem goes away, you step in as manager again, back in the driver's seat. And the reason is, a court can order you to do a lot of things, but it can't order a foreign trustee. It can't order them, but they don't need to reply. It's outside the jurisdiction. And so to hand over assets it now controls is not something they need to do. A plaintiff's attorney evaluating your assets isn't just looking for a number. They're looking at whether that number is even reachable. And once it isn't, a lot of cases that would have been filed simply never get filed at all. Fun fact, the law that makes all of this possible is the Cook Islands International Trust Act, passed originally back in 1984, specifically to create the strongest asset protection structure in the world. It's the reason the Cook Islands courts won't enforce a U.S. judgment against a properly structured trust. And it's the reason there's a statute of limitations that runs out on a creditor's ability to challenge a transfer at all. The assets are protected right away. They have a little bit of time to challenge, but we've never seen anybody win the challenge. Once that window closes, the assets aren't just hard to reach. Under Cook Islands law, the courts won't even hear the challenge. So that's not a gray area or a clever workaround. It's been settled law for over 3 decades, tested repeatedly in real cases, which is exactly why serious trustee companies guard access to it so carefully. Legal trivia: every properly structured offshore trust still comes with U.S. reporting obligations. Forms 3520, 3520A, like Alpha, filed annually. So this isn't a loophole or a secret, and it's not something a good firm hides from you. It's fully disclosed, fully legal structure, and any firm telling you otherwise is setting you up for a problem with the IRS instead of protecting you from one. I'll also tell you honestly who this isn't for, because it matters just as much as who it's for. You're currently being pursued by a government agency. If you have active or recent criminal exposure, if you're in the middle of a contentious divorce or trying to move marital assets out of reach at the last minute, no reputable trustee is going to take you on, and no honest attorney should be telling you otherwise. So that's not a loophole, to go find a workaround for. And that's the same filter that kept O.J. Simpson's case from ever going anywhere in the asset protection world. And it's the filter that protects the integrity of the structure for everyone using it the right way. At least we didn't set up a Cook Islands Trust Fund, that is, because we couldn't have. It was just me seeing if he would call, basically. O.J. Simpson may have been the most famous person who ever called me about asset protection. Well, I did get a call from Jay Leno also, so whoever's most famous there, probably O.J. But the people these structures were actually built for aren't famous at all. They're successful people who spent 20 or 30 years building something worth protecting, who had the foresight to protect it before somebody came looking for it. So that's not a story that makes headlines. That's just one that actually works. Now, if there's one thing I want you to take away from a story this unusual, it's this. The most interesting part was never that a famous name called. It was that a legitimate structure built on decades of law and reputation doesn't bend for anyone. Not for notoriety, not for money, not for a name that would generate more attention than any firm could ever want. The consistency is exactly what a plaintiff's attorney respects and exactly what protects the surgeon, the developer, and the business owner who set these things up quietly years before they ever really needed to. So thanks for watching. I want to see you again, so please subscribe if you haven't already. Click like so more people see this video. I really appreciate it. It's great to see you. Thanks for joining me, and we'll see you in the next one.